Okay, hi again, Attorney Steve Vondran. We're back. We are talking in this video about the Code of Civil Procedure, Section 1021.5. This is general legal information only and not legal advice or a substitute for legal advice. Okay, so we're talking about California Code here. So if you're from another state, this isn't going to apply. But you may have something similar in your state and you may want to check into it because this is California law. It's a really neat law statute that people need to think about when they're litigating. And in particular, when you have a case where there's no attorney fees that you can recover, and you go, well, sure would be nice if there was attorney fees that I could recover or a way that I could put pressure on the defendants to settle the case, because they know an attorney fee award may actually be awarded by the judge. So you want to have something. So let's go over, starting here, the American rule, okay? So if you're law students out there, you've heard of this, the American rule. What's that? Basically, it means that litigants pay their own way. That means if you're a plaintiff or a defendant, you have to get your attorney, you pay your own way. There's no recovery of attorney fees, okay, in general. Now, that is modified where you have a contract or a statute. Okay, so if you have a contract, a lot of times parties will enter into an agreement with another party that says, if there's a breach of this contract, the prevailing party can seek attorney fees, reasonable attorney fees. So that's a common clause that you will see in contracts. And as a law firm that drafts contracts myself, sometimes I want to put it in, sometimes I don't want to put it in. It really depends if you think you're going to be sued or someone's going to sue you, and whether or not you want to have an attorney fee award clause in there, okay? So the American rule is a general rule: pay your own way. If there's a contract or statute that allows for fees, then you can seek recovery. Now, an example on the statute: our firm does a lot of copyright infringement law, and under the copyright statute, the prevailing party, whether it's the plaintiff or the defendant, can seek their attorney fees. So that's an example of a statute that allows it. So a contract or statute, that will give you grounds for attorney fees. Otherwise, there is no attorney fee recovery, and each party will bear its own way. So we're going to talk about sort of an exception to that rule, and this is called our CCP 1021.5, and this is a law that allows you to go and get your attorney fees essentially by statute, okay? So here's the general rule. Upon a motion, a court may award attorney fees to a successful party. Highlight that, quotes around that, successful party, against one or more opposing parties in any action which has resulted in the enforcement of an important right affecting the public interest. So we have a lot of buzzwords here that we need to meet as a party seeking attorney fees. You need to have been successful, and it need to have had, the litigation has to have resulted in the enforcement of an important right affecting the public interest. Well, what's that? Public interest, that's broad. Well, that's the stuff that lawyers argue about. That's the stuff that litigants argue. You make the pleading to the court. So let's go down to our elements here. A, there needs to be a significant benefit. Significant is the word, and that's something you have to argue to the judge. I've tried to, whenever I used to file complaints in regards to real estate actions that I used to do, I used to argue that these activities of the banks were affecting the public at large, and I used to try to make these claims. Not successfully, candidly, was not successful because the judge said, you're just trying to help your client, and this really doesn't affect the public at large. Nevertheless, if you think you have the facts, you need to plead those in your complaint. A significant benefit, whether pecuniary or non-pecuniary, that means money for money or not money, has been conferred on the general public. Again, that's something we argue about, or a large class of persons. So you need to have something that's significant, you're successful, it's going to affect a large amount of people, and then you can argue for your attorney fees. B, the necessity and financial burden of private enforcement or enforcement by one public entity against another public entity are such as to make the award appropriate. So this means, as I put right here, the cost of litigation must place a burden on the litigant that is out of proportion to the litigant's personal interest in the lawsuit. The litigant bears the burden of showing that their personal stake was not sufficient itself to justify the lawsuit. So in other words, you have to show that the reason the suit was filed was really for the public interest, for the public benefit, and that the personal stake was minute. Sure, a plaintiff is always going to have some kind of personal stake in a litigation, or why else would they get involved? But you need to be able to show this was really something about public enforcement. So that's why they call this the private attorney general doctrine. You get to sort of act like a private attorney general. Usually an attorney general is going to do something that's significant, that sends a message to the public at large. Okay. Again, successful party, open to interpretation. What does that mean? Open to interpretation. Look at the pleadings. Did the plaintiff meet their litigation objectives? So that's one thing they're going to look at. Did the plaintiff meet their litigation objectives? Did they get what they were looking for? And that's going to be another question. And C, finally, such fees should not be, in the interest of justice, be paid out of the recovery. So the attorney fees, shouldn't be paid out of the recovery. The recovery should be used for the victims and whatnot. So there's your ABC right there. ABC. Again, we call this private attorney general doctrine. Courts have the inherent equitable authority under the private attorney general doctrine to award attorney fees to litigants who successfully pursue public interest litigation. So this is what we call private attorney general doctrine, vindicating important public rights. There's a case for you, the Alaska pipeline, noting that this private attorney general doctrine is not available in federal courts. Okay, so that's very important. You need to be bringing a state court action to seek to enforce this section. Okay, the case must have resulted in the enforcement of an important right affecting the public interest and conferred a significant benefit. Again, these are things you want to be making sure you're pleading the facts in your case. What defendant's doing is affecting a lot of people. There's thousands or hundreds of thousands or millions of people affected, something like that. Okay. Burden is on the plaintiff to establish that the litigation's costs transcended its own personal interest. We talk about that, that it's not a personal stake in the lawsuit that's the big deal, the big motivating factor, that's only minimal. Okay. Some examples, common examples here. What do you see? Class action lawsuits, consumer protection lawsuits, environmental lawsuits, something affecting the environment obviously affects a large number of people. Employment discrimination cases, ferreting out discrimination at the workplace. And as I put here, any case where you can make the argument, this is where you need to be thinking about it. If it's something where you can say, there's a whole lot of people affected here, a large class, then you may want to be making sure you're requesting, as in your complaint, as part of your prayer for relief, attorney fees under California Civil Code Section 1021.5. So if you don't ask for it, you may be waiving your right to seek that. Okay. What else do we have? Here's the other one. This is kind of a newer one. This is from 2003, what they call the catalyst theory. So there's another one where you don't actually have to per se be the successful party, but you have to be the catalyst in driving change in the defendant's behavior. Okay, so we got a case here, the Tipton-Whittington case. You can check that out if you like. But again, plaintiff's lawsuit is a catalyst for changing defendant's conduct. Okay, I also have the Graham versus Daimlerchrysler case. That's from 2004. There you had Daimlerchrysler advertising these 1989, 1988 Dakota trucks. advertised them as having a 6,400 pound towing capacity, when in reality it could only tow 2,000 pounds. So there you had Daimler Chrysler getting in touch with its customers, trying to offer cash and merchandise, a little concession. The local district attorney and I think the California Attorney General started wanting to get involved for false advertising. And plaintiff ultimately filed a lawsuit seeking return of their payments, compensatory damages, and attorney fees. And after that happened, Daimler Chrysler offered to replace or repurchase all the trucks. So, so first they came out and said, oh, well, we'll give you a little concession. And then after the attorney generals got involved and after plaintiff filed their lawsuit, obviously this was going to affect a lot of people. After they filed the lawsuit, then a plaintiff, went ahead and said, well, we'll buy the trucks back, since we essentially were not exactly representing things the way they were. So plaintiff's case was later dismissed as moot because, Chrysler had gone to say, well, we'll repurchase the cars. And of course, they were trying to duck out of attorney fees there. But, the court said, no, we're going to award attorney fees. It was nearly $1 million in attorney fees because plaintiff was the catalyst for making that change, for forcing them to do something. How you racked up $1 million in that case, I don't know, but that's what happened. All right, real quick, common fund. California also recognizes common fund and substantial benefit theories, where you can create a fund for the benefit of non-litigants. Okay, so look that up if it's something that may be important. Final point here is, do I need to send a demand letter first? I would say probably yes. Grimsley versus Board of Supervisors, California case. Supreme Court held attorney fees under 1021.5 will not be awarded unless the plaintiff seeking such fees had reasonably endeavored to enforce the public right affecting the public interest without litigation. The key right there, without litigation and its attendant expenses. So in other words, if you're thinking about filing a complaint and you're going to seek your 102.1.5 attorney fees, make sure that you're thinking about this case and sending a demand letter trying to resolve without litigation. If they won't resolve this and that, you got the letter, you got the track record, you can show, I tried, Judge. They were stubborn. They didn't want to do anything. They thought everything they were doing was right. And it's not the case. So you've got your private attorney general doctrine, you got your catalyst theory, you have the essential information here. You remember you're going to put it in your pleading and your complaint if that's the way you're going to go and seek your attorney fees. Otherwise, if you have another contract or another statute that allows attorney fees, then of course you're always going to be seeking your attorney fees. But getting your attorney fees is very important because that keeps the pressure on the other side. Whereas you can say, fine, we'll keep this case going on for 2 years, but remember, the attorney fee ward, Mr. Defendant Counsel, the attorney fee war is going up, up, up. So you might want to tell your client they're going to pay not only your attorney fees, but they're going to pay my attorney fees too. So that can help facilitate a settlement. Or if they don't settle, hey, you're going to hopefully seek a nice big, attorney fee award at the end of the litigation. Okay, so that's about it. There's my information there, attorneysteve.com, the first name in legal services. And I have a trademark on that, so I should be putting a little R at the end of that. I hope this has been helpful. General legal information only. If you liked it, give me a thumbs up. You like it, you can share it on your social media networks. And don't forget to subscribe. All right, I got to get going. Have a great day. We'll talk again.